Okay, ladies, so if I could please get you to start by introducing yourselves and talk about the jurisdiction you're here to discuss today.
Would you like me to start, Paige? My name's Julia Whittock. I'm representing Scotland, and I'm a retired solicitor with many years' experience, formerly ran the Will Writing Department of the Royal Bank of Scotland, taught at Stirling University, Trust and Succession, and I now run my own small business. Okay. In order to create a valid will in Scotland, there are three things which are required. Firstly, there must be capacity of the testator. The document must show clear testamentary intention, and it must be subscribed. So, capacity is a rebuttable presumption, so everybody's assumed to have capacity. Firstly, in Scotland, the testator must be full age, and that is over the age of 12, which I think might be a record. We'll see. It used to be 14 for girls and 12 for boys. It comes from Roman law. Now 12 for everyone. I have never had anyone under the age of 18 ask me to do a will, but they could do. Okay, next, please, Paige. The testator must be of sound mind. So we don't have a definition of sound mind, unfortunately. A lot of Scots law is based on common law, and so we tend to use, well, often we're just looking at case law. There is an abundance of case law on this topic, as you can imagine. There is a little bit of guidance and a little bit of help from a couple of pieces of legislation, the Adults with Incapacity Scotland Act 2000 and the Mental Health Care and Treatment Scotland Act 2003. But on the whole, we're looking at case law for that. It's the sort, I mean, I'm sure you'll all be the same in all of your jurisdictions. You'll have similar difficulties with case law.
Question up by Lime Tree.
Using a voucher?
Yes.
Yeah. Are you on the new
just
book
carry
now?
on, despite somebody who's not muted their microphone. If we could move on, please, to slide number 5, I think. I thought it would be easier, rather than to talk about what makes a good will. It's also useful to know how to reduce one, and there really are only 4 grounds. So non-age, i.e. somebody's under the age of 12, that they're insane, and again, a lot of case law on that. There's been facility and circumvention or undue influence of the testator. So either they've been a little bit weak and somebody has managed to get round their better judgment by manipulating them, or the person's in a position of trust and they've used that trust to unduly influence the testator to their own benefit. Okay, number 7, please. The next thing which is essential is for the document to show clear testamentary intention. So, for example, if a client were to sign a document which was clearly marked draft, or somebody tried to found on a letter which was written to a solicitor saying, I want to make a will in these terms, that would demonstrate that there was a future intention rather than existing intention. And even though those letters or documents were signed, they would not be testamentary in intention. So again, we've got an abundance of case law on that. So, and the third thing is that if you could move on to the next slide, please. The document must be validly executed. And in Scotland, we talk about subscription. So sub as in underneath. The document must be signed at the foot, at the end. The legislation in Scotland radically changed in 1995 with the Requirements of Writing Scotland Act. All documents signed after the 1st of August 1995, the new act applies to those. And so that's what I'm going to talk about. But bear in mind that if you were ever to see a will which predated that, then the rules are really very different. So today, the document must be subscribed. Section 2(1) of the 95 Act says there is no longer a requirement for a document to be witnessed. Now, obviously, that was a radical change in the law. However, Section 3(2) says a testamentary document will not be presumed to have been subscribed unless it's signed on each sheet. So in effect, what that means is the document must be signed at the end, but it also must be signed at the foot of each page. That is enough to create a valid will. However, a will in those terms signed in that way would not be probative. So it would not be self-proving in court. So therefore, in order to be self-proving, it must be witnessed. Since 1995, we now only require one witness in Scotland. So the document requires to be probative, to be subscribed, to be signed in the foot of each page, and to be witnessed by one person. Okay, so I think that was a whistle-stop tour of valid wills in Scotland. I will move on now to talk about intestacy. So intestacy, as we all know, I hope, is a situation where somebody dies without leaving any testamentary writing, whatever that is. In Scotland, we're working with very ancient legislation. The Succession Scotland Act 1964 is still in force, and it was based on the Mackintosh Report, which was commissioned in 1950. So if you think back to what society was like back in 1950, it was very different to society today. We didn't have the same number of people living together as unmarried people. And we also didn't have the same propensity to have blended families as we do today. So the Succession Scotland Act makes no reference to cohabitees. It needs to be updated. Everybody knows this, but nobody can agree how to update it. So there's been various law reports commissioned, but we haven't actually managed to come up with a good solution at the moment. There is also a presumption in Scotland that if the testator was known to have the will at the time he died, but the will can't be found, then there's a presumption that he has destroyed it. He or she has destroyed it. Okay, if we could go on to the next slide, slide 12, please. That's missing at 11 and going on to 12. The following one. Order of division. So when someone dies in Scotland, domiciled in Scotland without a testamentary writing that can be found, then the order of division is thus. Debts come off the estate first. Thereafter, prior rights. So these are specific rights to which can be claimed by a surviving spouse or civil partner. That may be all the estate there is. There may be nothing else. However, if there are other assets, then the children and or surviving spouse or civil partner can claim what are known as legal rights, and I'll explain what those are. And then anything else that is left falls into what we call free estate, and there's an order for inheritance of that. So if we could just miss that slide and go on to the next one, prior rights. So prior rights can be claimed by a surviving spouse or civil partner. There are three distinct parts and they can be claimed separately or together. So the first is the prior right to a dwelling house, which the surviving spouse lived in at the time that the deceased died. The deceased doesn't need to have lived in it, but the surviving spouse does. The thinking behind that being that the surviving spouse or civil partner should be able to carry on living in the same house without having to sell or move. There is a maximum value of £435,000, which applies to the dwelling house. So they would inherit the house up to that value. If the house that they are living in is worth more than that, they would receive a cash equivalent, which would mean obviously selling the house and moving, or buying it out. They're also entitled to the furniture and plenishings, love that word, i.e. the contents, up to a value of £29,000, and also to a cash lump sum of £50,000 if there are children, or £87,000 if there are no children. So that's what the surviving spouse or civil partner is entitled to. If there are more assets, then there's a possibility that the children and the surviving spouse can then claim what are known as legal rights. These are common law rights which have been in place in Scotland since time immemorial. They apply whether or not there's a will. So even if there is a will, should that will not mention a spouse or children, those children can still claim their legal rights. I think that's different in England. I'd be interested to know. But in Scotland, it's always been thought that someone should not be able to die and not take care of their family. So the right is only to movable property, i.e. everything which is not heritable, i.e. everything which is not land and buildings. So we're talking about everything else: premium bonds, cash in the bank, valuable assets, any sort of insurance proceeds. I'm sure you can imagine anything that's movable, physically movable. And the surviving spouse is entitled to half of that if there are no children, and to a third if there are children. The children are entitled to a third between them. So if there are 6 children, they get a sixth of a third, and if there's only 1 child, they get a third. Okay, so that comes off next. And then the free estate. So everything else which is left will go to the children if there are any. Very recently, this year, in fact, the spouse is then the person who inherits if there are no children, and the list goes on as such, which I've listed. So that should take everything that's in the estate. Bear in mind, I think it's important to know that in Scotland, the age of majority is 16, so children inherit at 16 if there's no trust provisions in a will, and also that vesting takes place at 16 if there's no provisions in the will, contrary to that. And their cohabitees have virtually no rights. They can only claim on intestacy, but even if it is an intestate estate, they have no automatic rights. They have to make a petition to the court under the Section 29 of the Family Law Scotland Act. Okay, I don't know how long that was, but it felt very brief.
Perfect, Julia. Thank you so much.
Okay.
I'm from all of the practitioners watching today. The thing that really baffles me is that you only need 1 witness. Found that really interesting.
Yeah, that's a very recent thing, but yeah, I don't know what the thinking was behind it, but yeah, we only need to have 1 witness.
So please, can I encourage you all to leave any questions you have in the chat box, and we are now going to move on to our very lovely Lucy Cresswell.
Hello, so my name's Lucy Cresswell. I'm a solicitor in the private client team at J&W Solicitors in Manchester. So I'm going to cover kind of UK validity of UK wills and kind of intestacy rules and how the estate is distributed. So I'll start, because we've only got 10 minutes, with the validity of UK wills. To begin with, kind of what is a will in the UK? It's the legal document. Everyone
I'm
has
really, really sorry to butt in, but it's not UK. Scotland's part of the UK.
in England and Wales.
Yeah, so it's not UK. This is England and Wales.
Yeah.
Just wanted to make that perfectly clear.
Yeah. Thank you. So it's the will that where someone declares their intention as should what should happen to their estate on their death. It is executed in accordance with certain formalities in order to make the will valid, which is under the Wills Act 1837, which is the main legislation that governs the kind of formalities of the will. In order for the will to be valid in England and Wales, the person must be 18 or over. So it's quite a lot higher than the the previous discussion, made voluntarily without pressure from any other person, made of a person who is sound mind, in writing and in the presence of 2 witnesses, which is extremely important in England and Wales that it's in 2 witnesses. And it must be signed by the 2 witnesses in the presence of the testator. So those witnesses have to actually be there in person in order to kind of see the testator signing the will. But it's really important to watch out for when the witness is a spouse or civil partner, because they cannot benefit from the will. And then if the witness of the will is also a beneficiary, the will still be valid, but the beneficiary won't be able to inherit under the will. Thank you. So the execution of the will is extremely important, and if it's not carried out in the certain kind of formal requirements, then it can cause a lot of issues on probate, which I've dealt with myself quite a lot. The will must be in writing and the testator must sign it in the presence and at their direction. The testator, the main concept is intention by their signature to make sure that they actually give effect to the will. It's usually advisable that they sign at the end of the will. That's what we encourage. Above the witnesses' signatures, it avoids kind of uncertainty about their intention, which can give rise to inquiries on probate. The testator can sign by leaving a mark. I've seen it before when it's just been a thumbprint and it's still been accepted through probates. So it must, as long as it appears that the testator's intended by their signature to give effect to the will, then that is usually valid. The signature must be acknowledged in the presence of at least 2 witnesses at the same time. So during COVID and kind of when everyone was self-isolating, people were actually witnessing wills through windows, and it was still valid as long as the witnesses were in the presence of the testator. If the testator acknowledges their signature, the witnesses must either see them or have the opportunity to do so. Each witness must sign the will or acknowledge their signature in the presence, but not necessarily in the presence of each witness. So it is really important that is carried out. Best practice is usually to avoid any ambiguity that the testator comes into the office, which is the way that we do it, and then it's signed in the presence of the witnesses. The will can be valid if the witness is signed before the testator, provided that they've acknowledged their signatures and they've acknowledged their own signature. However, that is a very old legislation, pre-1983. There's not any statutory rule about where the witnesses need to sign, but it's advised for them to sign at the will. I'm sure a lot of practitioners, you will have your own precedent wills that you use, and that's the usual common form of way to do it. Otherwise, when it comes to probate, you are going to have to get an affidavit or witness statement, and that might be required. We advise, and a lot of practitioners do, to use attestation clauses. It's not strictly required. However, if there's no proper attestation clause, then affidavits and witness statements might be required. There can be a lot of defects that cause issues in probate when execution of wills isn't carried out properly in England and Wales. The first way to kind of remedy a defect could be through rectification. So you can apply for rectification of a will that kind of fails to carry out the testator's intentions, maybe due to a clerical error or failure to understand their instructions. That can be done within 6 months of the grant of probate. Another one I've recently had an issue with was there was no date of the will. If the testator hasn't dated the will, but there is no other defects kind of in the execution of the will itself, they can insert the date afterwards if they confirm what date it was. If the testator confirm the date, but it's not feasible to then write it in, then the practitioner can write in the date. Another one that people might be very familiar with is the physical condition of a will. It's kind of sworn not to staple the wills. It's just a good idea to advise testators to not attach any letter of wishes. People love to put a side note about their funeral wishes, what they want to do, but just it's best to just say to keep those completely separate. There's a lot of kind of mixed case law on the duty of solicitors supervising execution. It's just not entirely consistent of how that should be done. The safest course of action that is advised in England and Wales is that whoever prepares the will, they recommend that they sign at their office or they'll visit their home and the witnesses are present. And if the testator doesn't accept that advice, then they should record it and make sure there's clear written instructions on how to execute the will. Yeah, next slide. Thank you. So there are formalities to carry out in special situations due to the testator's different characteristics in England and Wales. The first being having a lack of mental capacity. A person that lacks testamentary capacity cannot make a will. However, the Court of Protection can kind of apply to get those statutory will applications in place. If the testator had mental capacity when the instructions were given, that when they come to sign the will but didn't have capacity when they came to give their will instructions, maybe still be able to make a valid will. It's in the case law of Parker and Falgate. According to this rule, the will can still be valid if when the testator comes to execute it, it can be shown that they had testamentary capacity when they gave the instructions. They remember giving the earlier will instructions and they understand. The main concept is understanding that they are about to sign and prepared to follow with those instructions. Another one that was really important is when someone is blind, unable to sign or unable to understand English, the probate registry will always and most always ask for evidence that a testator that was blind or directed another person to the sign will or didn't understand it. They will require kind of an affidavit or witness statement to prove that. A signature by mark that is incomplete or unusual is likely to be treated in a very similar way. So it's just important to make sure that the attestation clause confirms that when the will was read over to the testator before it was signed and the testator appeared to thoroughly understand it, it's just normally enough in usual situations for probate. So yeah, next slide, please. Thank you. So now I'm just going to touch on the intestacy rules in England and Wales. So if someone does not leave a will, their assets will pass in accordance with the rules of intestacy. They only apply to property that the deceased could have left by will. So the intestacy rules won't apply to things that pass by survivorship. Say if they held their properties as jointly or joint bank accounts, nominated assets, life insurance policies, pension benefits. Usually pension benefits and life insurance, they're paid by the trustees of the pension funds or there's discretionary. In relation to the residuary estate of the intestate, assets regulated by kind of foreign jurisdictions, that also wouldn't apply under the rules of intestacy. So there's a very complicated flowchart on the slide. I'll leave you to kind of look at that. I won't go through it step by step. But the UK statutory rules that govern the administration and distribution of the estate is under the Administration of Estates Act. The order of entitlement under the intestacy rules depends on the value of the estate and which members of the family survive the intestate. So a lot of genealogists will pull up a family tree and then you work it out who is entitled to benefit. The right of the family member depends on their relationship to the intestate and who is the closest relative to survive. General principle is that the estate is shared between the closest relatives to the deceased to the exclusion of those in the lower category. So yeah, next slide, please. Thank you. So statutory trusts are also really important. So the effect of the intestacy rules is that the intestate's personal representatives will hold on trust all those assets that they didn't dispose of in their will. The personal representatives then have power to sell those assets, and the statutory trust rules is very similar to an express trust in a will and gives the personal representatives powers and duties to distribute the estate. And finally, the consequences of the intestacy rules. In certain situations, it might be that it's unfair. We've seen it a lot when we pass it to the contentious probate team that claims can be made under the Inheritance Act 1975. Obviously, it's unfair, but some people might feel that they're not being adequately provided for, but those are the rules in England and Wales. So yeah, so that's the scope of the intestacy rules, and thank you for listening.
Thank you so much, Lucy. That was so informative. One thing I'd love to pick up later is about the attestation clauses and the importance of them. I've come across wills where practitioners haven't amended the attestation clause just purely because they didn't know about the amendments to be made to it. So that's a really good point. And also the contrast between the age of England and Wales and Scotland as well. So loved that. Thank you so much.
Thank you.
Again, any questions, please pop them in the chat. Now coming on to the very wonderful Leah Magnard. Leah, please introduce yourself.
Hi, good afternoon, everyone. So my name is Leah, and I am one of the French lawyers with the international team at Bocals. I actually celebrated my 9-year anniversary of moving to the UK last week. So I've been here for quite a while now, and you're not getting rid of me anytime soon. So, all right. French will. So, obviously, we only got a very short time slot today, so I've kept it quite succinct and to the main points. Obviously, France is a civil law country, which means that things are going to be very different from what we've just seen with Scotland and England. And in general, in France, people just don't use wills. It's not at all culturally the norm like it is within the UK. But weirdly, for a country that doesn't use wills very often, we've got 20 million different types of wills that a person can make. So I've picked the main 4 types of will to explain those to you today. So the first type of will, which is the most frequent we would come across, is a holographic will, which is literally just a handwritten will. It's very easy to put in place because there are absolutely 0 formalities for your will to be valid. However, it is simply just not a very inclusive type of will. If you are disabled in such a way that you can't read or you can't write, or if you're too ill or too old to do that, you simply can't make a holographic will. But it does provide some flexibility in that you can just simply make your will at home whenever you want. Obviously, the risk with that is that people feel it is so casual that they don't want to take legal advice and they would just write their wills, and it will end up not being entirely valid or just cause a lot of issues with very poor homemade self-drafting. On the other end of the spectrum, you've got the authentic will, which is done through a French notaire. It is extremely, extremely formal, and I'll explain how it is executed in a minute. But what it means is that it is almost impossible to contest this type of will due to the way it is executed. This is a type of will that you have to go through if you want to establish filiation. So filiation is the legal relationship between parent and child. In France, it is extremely important because we have forced heirship rights, which are statutory rights given to someone's children. So if you're not named as someone's parent on their birth certificate, you are able to acknowledge them as your child doing an authentic will. So you can imagine the family drama that happens when someone acknowledges filiation through an authentic will. It's also the type of will that you have to use if you want to deprive your spouse of some of their rights to occupy matrimonial homes. I'll explain those in a minute when we talk about intestacy, but it is considered to be such a grave thing to do that it must be done in the form of an authentic will. Then you have the mystic will. I have never seen a mystic will. I am not too sure what the use is, but basically it's a will that is sealed in an envelope and you present it to a notaire in the presence of witnesses saying, here, this is my will, and nobody sees it. I assume maybe a celebrity who is going to leave things to their mistress and want to make sure the tabloids don't get hold of their wills will use the mystic will. I am yet sadly to advise a celebrity with a mistress, so I've never come across a mystic will. The last type of will you can have in France is an international will under the Washington Convention. It is very rarely used. It is even more formal than an authentic will. As a result, it is extremely expensive. And we've got a lot of other means to have a will which is valid across jurisdiction. I've seen one international will, actually, we managed to admit it to probate in England, so that was a really interesting one to deal with. But really the only time I would advise an international will is if you've got a jurisdiction that is not party to the Hague Convention, because the Hague Convention is a lot easier to rely on. That's the Washington Convention. So basically, if you've got a will that you want to be valid in Canada, is when I would use an international will. So execution of the 2 main types of will. Holographic will, the law says, entirely handwritten, signed, and dated. And that is usually it. There is absolutely no need for any witnessing. And it has to be handwritten. No part of it can be typed. So if, like me, you've got a terrible, terrible handwriting, probably not good to do a holographic will. Very recently, a couple of years ago, the French Supreme Court also said that the will must be understood by the testator in that they must be able, when taking their will, to read it and know what the will says. And the case was a case of a German national who made a French will and who wrote it in French when he didn't speak French. So obviously somebody translated the will into French and told him to copy the French, except he didn't have a clue what the French will actually said, and it was found that the will was not valid. It's quite an important case law because sometimes we argue with notaires when we want to register a holographic will written in English. They say, well, no, it's a French document, should be written in French. So now we've got actually a case law to tell them, no, that's not entirely correct. Please register our handwritten French will in English. Because they're so casual, there is a lot of case law about them. So on the issue of the date, recently we've had a very cool case where somebody wrote their will on the back of a bank statement. They didn't date it, but because the bank statement itself was dated, the Supreme Court said, no, that's fine. You can determine approximately when the will was made. So it's fine. It's a valid will. And then you've got your very classic cases that you learned about as a student at university. A postcard will. Dear daughter, tomorrow we are going on a helicopter ride. If anything happens to me, the house is yours. Yeah, that's a valid French will. And it was absolutely upheld. Or you've got the case of a will written on a wall in quite grim circumstances that I won't go into, but that was also acknowledged to be a valid French holographic will. For an authentic will, you need to be in person in your notaire's office. They're always very fancy. It looks very, very, very formal, with 2 independent witnesses, or you need to have 2 notaires. So if you want something a little bit more confidential, but you don't want to go as far as doing a mystic will, then it is fine to just do your authentic will with 2 notaires. The authentic will must be in French, which means that if you do not speak French, there must be a sworn interpreter attending to help you understand your will. So as a testator, you will dictate your will to your notaire, who will type it, read it back to you, and then everybody signs. So it's quite a, it's quite a process. And France being a very formal country, there has been recent case law where there was an interpreter who was not sworn, and the will was found not to be valid just because of this. So there is currently a battle between the French Supreme Court and the appeal court in Lyon, because we don't have a doctrine of precedent in France. So the appeal courts like to resist when they don't agree. Anyway, the 2 courts are battling as to whether this will should be valid. So there will be some really interesting case law for us to follow up on. But yes, that's how you execute your 2 types of will, main types of will in France. In terms of validity, we have got the Hague Convention on the International Validity of Wills. And that's a convention that says that a will which is valid under the convention in one country will automatically be valid in all of the other party states. For us, what this means, because the UK is a party to the Hague Convention, is that a French will is automatically valid in the UK, and we have admitted holographic French wills to probate several times. And obviously the opposite is correct as well, is that a valid English will or a valid Scottish will also is automatically valid in France. That's something that practitioners are not always aware of. It's actually dated back from the 60s. It's got nothing to do with the European Union. So it's quite an important convention to be aware of. Our main issue with validity in France is substantial validity with the forced heirship limitations. Forced heirship is when you can't disinherit someone. So what French law does is it says there is a part of the estate that is reserved to some beneficiaries and what part of the estate that you can dispose of freely. If you are married and you don't have children, your spouse has a quarter share that is reserved. So in France, you can disinherit your spouse for 3/4 of the estate. Spouses are not treated very, very well under French law. If you've got children, it depends on the number of children that you have. So if you've got 1 child, they must receive half of your estate. 2 children, they must receive 2/3 of the estate equally between them. 3 children or more, they must receive 3/4 of the estate between them, which means that you only have a quarter you can deal with. Your available portion, you can do whatever you want with it. So you can either prioritize one of your children that you like the most, so you give them more than their siblings, or you can give it to charity or to a third party or to your spouse. So that's how the forced heirship work. If you make a will that doesn't comply with forced heirship, it doesn't mean your will is not valid. It means that your children can ask for whatever legacy is done above and beyond what you could do is reduced. So it doesn't mean that whoever you wanted to benefit more than your children won't inherit at all. It just means that they can only inherit a specific amount. And as you can imagine, then everybody argues about how to actually calculate that amount. Obviously, there are lots of bits about validity, age, etc. I decided to focus on some bits that were very specific to France. A French will does not get revoked by marriage. So that's quite an interesting one. And actually, I was talking to some notary in France who found out that English wills were revoked by marriage, and they were starting to be horrified and considered whether they had ever applied an English will that was actually revoked. But yes, in an international context, it becomes really interesting, because what if English law is a substantial law applying to your estate, but your French is a French form will? Is it revoked by marriage? It's not revoked by marriage. So it's obviously quite an interesting point. I'm not aware of any case law on it, but that's an interesting point on validity. And then one last one, the envy of the world. We have a central wills registry in France. It's not mandatory for a will to be on the registry, but it is obviously best practice. You can imagine a holographic will. It doesn't look like much. It could be on a postcard. It could be, just on a piece of paper, which means that it's very easy for it to be missed or just binned when you're clearing the paperwork. So what you do is you give your original to the notaire. They put it on the registry. Any notaire who administers an estate in France will check the registry. It is the first thing they do. So that's it on French wills. If you can have the next slides, yeah. So the French intestacy rule. So because the French don't make wills very often, almost 90% of the estate are actually administered on the basis of intestacy. One point of note is that in France, civil partners do not benefit under intestacy, and they're not assimilated to a spouse like in England and Wales. So if you're in a PACS, in a French civil partnership, you're exempt from inheritance tax, but if there is not a will, you're not inheriting at all, which obviously can cause a lot of upset, especially at the moment. There is always, a gray area as to whether an English civil partnership would be acknowledged in France as such, and whether you would get a right under intestacy or not. If you are not married, you've got your 4 categories of beneficiaries, and if at least one blood relative from a category exists, then the first 3 categories are excluded. They're very, very similar to what we've seen in Scotland or in England. So just to mention one point of difference on that is that if someone is survived by both parents and siblings, they inherit together. There isn't a case where the parents inherit by themselves, unless obviously there are no other siblings to the deceased. If you are married and you've got children from the same relationship, the spouse gets a little bit of a priority in that they actually get to decide how much they're inheriting. Either an usufruit, which is a bit like an interest in possession of the estate, or a quarter outright. So if you are a spouse, you can inherit. Your rights are still not massive like in England. So it's really quite a difference between both countries. If the spouse dies without opting, which can happen quite often, they would be deemed to have opted for this usufruit, so this interest in possession right. But that is if all of your children are from your spouse. If you have children from a prior relationship, then French law says that ideally we don't want those people to have to deal with each other for the rest of the spouse's life, and to have some sort of clean break between them. This option is removed and the spouse only inherits a quarter. So if you want your spouse to be protected in France, you really have to make a will, because it will give you, the law allows for some enhanced rights for the surviving spouse, but only if you make a will. You won't benefit from them under intestacy. To still protect the spouse a little bit, but that's only as recent as 2005. So until 2005, the spouse was really not having a good time in France. you have some statutory rights over the matrimonial home. There is a temporary right of a year to live in the matrimonial home at the cost of the estate. This one, nobody can remove it from a spouse. Then afterwards, you've got what's called the droit viager, which is a lifetime right to occupy the property, but then it is at your own cost. So you can't ask the estate to pay for it. This one is one that you can remove using an authentic will. So you could absolutely disinherit your spouse from the right to live in your property after this first year. And again, civil partners do not benefit from those rights over the matrimonial home. One particular last point in terms of the French intestacy rules and what constitutes the estate is the droit de retour. In France, lifetime gifting is quite popular, and very often we will have this provision inserted, and it's a bit like a sling back in that if a person dies without children, the gifted assets will go back to the person who gifted them the assets. So let's say as a parent, you give your child a house. If they make a will saying, I give my house to my good friend, actually they can't do that because the asset is automatically going to sling back to the parent. So it's the same under intestacy. Every asset with the droit de retour will just go back to the parents and actually not form part of the estate that would be inherited. And I put my Parisian brand on and went through this at like 100 miles an hour. And that was it on the typical French wills for me.
Yeah, that was so interesting. Thank you so much. I'm just going to pick a little bit out that I really enjoyed from that. It's the whole idea around a mystic will. Now,
I love it.
It's very serious around it, but for me, it sounds really mystical. And I just love that. It's so interesting to see the different types of wills. So thank you so much. Again, let me encourage you to pop any questions in the chat. Right, we are now going to move on to the very wonderful Rosa. Rosa is in Barcelona at the moment, so she is an hour ahead of us. So Rosa, please take the floor and introduce yourself.
Thank you, Paige. Well, good afternoon, all of you. I'm pleased to be here. Sorry, Paige, I don't know if you see me on the screen.
I can. I don't know if everyone else can. I'm hoping they can.
Yeah, we can.
Yeah, it's working. Yeah.
Okay. I didn't see it as it was me on the screen. Perfect. So it's nice to know it. Yes, I'm a Spanish qualified solicitor. I've been practicing for 20 years now. And since I've been in the UK some time ago, I've been dealing with my colleagues in the law firm with British clients who want to do a will related to Spanish assets. So in our case, in Spain, when we have a client who has bought properties in our country, in Spain, and they are British nationals, what we tell them is that we advise that they do a will referred only to Spanish assets. Usually, our clients will have two wills, one English will referred to worldwide assets except Spain, and then a will referred to Spanish assets only. These two wills need to be coordinated. That's of essence. We found lots of cases where the English will can revoke the Spanish will if the Spanish will was done previously to the English will. Why? Because they don't make an exceptuation they don't put in the writing of the English will that the Spanish assets have to be exceptuated of the English will. So very, very important concept from the beginning, in my case in Spain, is that any British client that owns property in Spain has to be advised to do a will referred only to Spanish assets in Spain, but in coordination always with her English will. We all have clauses in England and in Spain that we can write on a will, and these clauses will avoid that one will revokes the other. It's very easy, it's very simple to do it, but we need to know it. So when we do a will for a client refer to Spanish assets, we send them a questionnaire, and one of the main questions is, do you have an English will already? If you don't, we will only refer to Spanish assets, of course, and we will not mention any other wills. And we say that basically, if they do have an English will, that the English will is respected, that we don't revoke the English will in Spain by doing the Spanish will referred only to Spanish assets. So we just focus the Spanish will done but for the Spanish assets that affects to the assets in Spain, not to the UK assets. Having said that, basically, in Spain we have three types of wills. We have the holographic will, as our colleague in France was explaining very well. It's nearly the same. We can do an holographic will, but here in Spain, it's very rare. We don't usually use it. Why? Because it usually has to go through court. It usually has to be validated by a judge. So that takes time and that complicates matters. So we try to avoid that will. Holographic will is, as my colleague in France explained, a will handwritten, dated, signed by the testator, testatrix, and then registered at the Last Wills Registry in Spain. The Last Wills Registry in Spain is an administrative corpus that will register all the wills that are done related to Spanish assets. We have also what we call the closed will. A closed will is done with the intention that nobody knows what the will says. As the word explains, it's very explicative. It comes with a closed envelope, sealed envelope. That's one of the formalities. And the other formality is that the notary in Spain seals the envelope. They don't seal the actual will, the current document, where everything is explained, but only the envelope. And then this envelope is registered by the notary in Spain at the Last Wills Registry in Madrid again. That's the official registration office we have. And it's very, very useful to find the will and to do a will search when nobody knows where the will is from the family. So the usual will we have in Spain is called open will. And in fact, the open will can be done in Spain, but it also can be done in the UK. We've done some open wills in the UK with English notaries. Basically, when we do the open will in Spain, we use a notary in Spain who will write the will in Spanish only. If the testator or testatrix don't understand the Spanish, it can be translated in writing or by a translator, official translator that will be named in the will. And then this will doesn't need to be witnessed. It's necessary that the notary signs it and that the testatrix or the testator signs it as well and date it, okay? So once these formalities are followed, the will is sent to the Last Wills Registry in Madrid by the notary, always. The notary has to send it. In comparison to the open will done in the UK, referred to Spanish assets only, we find the notary in the UK. The testator or testatrix will go to the notary in the UK and will sign a double column, Spanish and English content of the will. And then two witnesses will be required because the formalities in the UK, in fact, as my colleagues were explaining, you need two witnesses. And the will has to be validated by the Hague Apostille as a foreign document to be used in Spain. The Hague Apostille is a seal that the Commonwealth Office in London will stamp on the will. And then this will has to be sent, usually by us, by the solicitors, to the Last Wills Registry in Madrid. We send them a letter asking the registry to register the will. So we know the date the will was done and the name of the notary before who the will was done. So what happens that in this case, if the will is lost, we can find the notary at the will search, and we can see when it was done. So we can request an authentic copy to the notary that did the will, basically, and we can obtain a copy and we can find the content of this will. So the last wills registry in Madrid is it's a very useful tool that we usually have in hand, and that we usually go when we have to do a will search. And we will basically need the name of the testator or the testatrix and passport number. And with these two parameters, we can basically find when the will was done, the date, and the notary who did it, and then ask for a copy. So this is something I wanted to mention because I know in England we have problems sometimes when the will is lost. You have to go to different solicitors, find out if the will was done, inquire to different law firms, and it can be a hassle, and sometimes it's not found. But in Spain, we've got this little advantage that we have a registry and we can inquire the registry if necessary. Basically, about the validity of the will, it's as usual, the age of the testator or the testatrix has to be 14 or over, and they need to be fully capable of deciding by themselves. This is mainly what we look into, and there can be claims when there are suspicions that the person who did the will, the testator or the testatrix, were forced to do that. That's something we've seen sometimes in court, but usually this is very much looked after by the notary who witnesses the will in Spain. Basically, when we talk about applicable law to wills done in Spain referred to Spanish assets, regardless if the testator is British or any other nationality, as long as the asset is located in Spain, the European regulation dated 2012 and applicable from August 2015 applies. What does it mean? It means that the law applicable to succession for the British who pass away with assets in Spain is European law. So if they die intestate, if they die without a will, which law do we apply? We apply the law of the last habitual residence of the testator or the testatrix. Sorry about that. So the law of the last habitual residence of the testator or the testatrix is where they died, but not only where they died by chance, because someone can die on holiday, is where they spent their last 5 years of residence and where they can show that they have strongest links with family, with work, with tax residence, etc. So it's a matter of finding out where did the testator, did the deceased in this case passed away. So, for example, if a British national who has retired in Spain dies without a will, dies intestate, the law of the last residence, the law of the last habitual residence will apply according to European law. And which is the law of the last habitual residence? Spanish law, because they spent the 10 last years, or he or she spent the 10 last years of her life in Spain. So what does it mean? That because he didn't do a will with the professio juris, that means choosing that his national law, his British law, would apply to his inheritance. He didn't take this choice with a will. Now he dies intestate and he dies in Spain, and Spanish law of forceps hair will apply. So that means that they have to apply to this inheritance the law of Spain. The law of Spain, in terms of inheritance law, is very different to English law. If you do a will choosing your English law and applying your English law, the testator or testatrix can choose who they leave the property to. They have freedom of disposal, we say it. If you do a will by choosing a Spanish law, you don't have freedom of disposal. You have to obey the forsus heirs. The forsus heirs are usually the children who need to inherit by law 2/3 of the inheritance. Okay, so choosing the law in a will, it's very important for British nationals. Choosing British law is a must, is fully recommendable. And doing a will with the possibility of choosing English law, it's for us, it's of essence, because it gives British nationals lots of advantages when disposing of their assets in Spain. So if they die without doing a law, if they die intestate, English law will apply if they die in England, but Spanish law will apply if they die in Spain, if the last residence is in Spain. So which are the rules if the last residence is in Spain? The intestacy rules in Spain are that the one who inherit the assets of the deceased are the children plus the spouse in first instance. The spouse, the same in France, only gets the life tenancy. They only get the right to enjoy the property, the assets, anything left, but not to own it. So the spouse, well, it's in disadvantage in comparison to the children who would inherit everything in ownership. If there are no children, it goes to parents, and the spouse gets again the life tenancy of the half. But again, the spouse is not the owner. The spouse is the one who enjoys the assets, but they don't get the ownership of it. It's the parents if there are no children, and then it goes to the spouse if there are no parents and no children alive. So basically, my intention today was explaining more or less how it works in Spain. It's very important to tell clients who own property in Spain to do a will referred only to Spanish assets without revoking any previous wills in the UK, of course. So very careful with all the clauses in the wills. And basically ask your clients to do a will in Spain, because if they die in the state, it's very, very advantageous. And basically, they don't have the chance to choose the English law that would apply to their inheritance, and therefore they don't have the chance to have freedom of disposal of their assets when it comes to estate planning. I hope it's been useful, and I hope you have been able to sort of understand the necessity of doing wills related to Spanish assets. And well, wanted to thank you very much for your time today. Thank you.
That's fantastic, Rosa. Thank you so much. I think there's just so much importance really on establishing what law is in the will. So always choose the right law in the will when you're making a will in the UK. We're going to have lots of questions on the different wills and attestation clauses and EU election clauses as well. So thank you again. Now on to our wonderful Yasmin. Yasmin, if you are there, my woman, please may I ask you to introduce yourself, and then after Yasmin we will do questions and answers. Thank you so much.
Yes, I hope you can all hear me. I'm Yasmin Hock. I'm a solicitor for England and Wales, and one of the things I specialise is Islamic wills in England and Wales. So the first thing you'll see on the slide is that the relevance to Islamic wills actually cuts across many jurisdictions, so approximately 14 jurisdictions worldwide. And I will no way suggest that I know the ins and outs of all of the different applicable validities and executions in those jurisdictions, because as we've seen from today, each jurisdiction has its unique aspects. But the key thing to note is that Sharia or Islamic rules are applied in many countries just because they are part of the Muslim faith. And in England and Wales alone, according to the 2021 census, there are 4 million Muslims. So the relevance of it for today is that will writing and wealth management is prescribed within the Islamic scriptures of faith. So there's guidance not to let 2 nights pass without writing a will, and also instructions to ensure that the next of kin are provided and cared for. So that's an obligation that carries on beyond the grave. Muslims, regardless of nationality, will seek to fulfill this, and many are not aware how to ensure legal and religious validity, because as we have seen, every jurisdiction does have its unique aspects. In most jurisdictions, it is possible to write a will. So the will aspect is known as wasiya in Arabic, regarding the bequests. And this provides a Muslim believer the freedom to dispose as they wish within Islamic principles of up to 1/3, or roughly 33%, as a maximum of a person's estate. This provision is what is often regarded as the Islamic will, because the aim of it is either to benefit a charity. Usually the charitable causes have to be doing something which is classified as an everlasting benefit, such as a well or educational establishments that you're contributing to. This is so the deceased Muslim believer benefits from the ongoing deeds as a perpetual reward in the afterlife for what they have strived to achieve in the living life. It can't, however, be used to adjust or interrupt any of the Islamic inheritance rules that are prescribed within what is known as the Sharia law. And that law is found in the primary source of it in the Quran, is the instructions there. So I will later on explain some of that content. But the key aspect as to validity of the will hangs on not exceeding the 1/3 portion and only including bequests for those individuals who are not already primary or secondary inheritors. So the safe option being to avoid blood relatives and spouses within this 1/3 content. When we're talking about execution of such wills, this also requires the content that we've already heard from the panelists about soundness of mind, being the correct age, not being under any undue influence, having the appropriate witnessing, attestation clauses, and that is essentially following the law of the land as to legal compliance of the document itself, whilst bearing in mind that some Islamic will jurisdictions who are applying it in full will permit oral bequests as well, whilst others will insist on it being in writing. And where those jurisdictions have got judges that are appointed to practice in Sharia law, so they have the religious qualification and the legal qualification, that case law has developed over many, many years, and each jurisdiction will have slight differences on what they regard as a valid will and what they regard as suitably executed as well. I'll move on to talk a little bit about distribution, because that is relevant across the jurisdictions. So as mentioned, the primary source for this is within the Quran, which is divided into 114 chapters. Those are referred to as surahs, and each one does have a different name. And within each chapter, there's various religious, faith-based guidance. But if you're looking for will writing content or supporting Muslim clients, then you will learn from chapter 4, which is known as Surah An-Nisa. And within there, there's verse 12. I'm not going to read the whole verse, but in there, if you take a look, you will find that in terms of distribution, you first deal with this 1/3 bequest aspect. So has someone written something for this 1/3? Have they initiated it? Then you go on to debts being distributed, and these debts will include what we're all familiar with as regarded legally as a debt, but it will also include any religious debts. So these could be, for example, any unfulfilled duties towards prayer or fasting, which are the pillars of faith. It could be unpaid obligatory charity over the years. In there sometimes can be the husbands, if they have specified marital gifts as part of the marriage contract, that forms a debt if they haven't paid it in the lifetime or upon marriage. So these you'll find variations of schools of thought at the level of debt and also the category of debt and what should be deducted before going on to the actual distribution. So when I'm preparing wills for Muslim clients in England and Wales, we actually come across the very diverse spectrum of thought because there may have been learning from many different jurisdictions. Some of that will have been actual case law, man-made case law that has developed over time in those jurisdictions, and some of the knowledge is authentic faith-based content. So we have to unpack all of that and then put it back together into what is it that the testator had expressed here. One of the key things that is helpful to do if you're supporting a Muslim client is to support them in capturing this at the time of instruction taking, what they regard as current debts, and keep a reminder built in over the lifetime that they can update and review a bit more frequently than a typical will. I tend to encourage clients to review it once a year if possible, but as a very basic level, at least 3 years, so that we can be sure nothing is missed out or we don't have a large calculation to do when a person's no longer here and we're trying to distribute according to their wishes. It is also, when it comes to distribution, worth searching for any declarations or adjustments that may have been discussed during the lifetime, because whilst we'll look at what the Sharia fixed succession rules are, in the lifetime, there isn't any such religious restriction. So for the lifetime, there could be a lot of gifting going on, a lot of different wishes amongst the family members that they want fulfilled afterwards because nobody's selling, for example, the residential home, or perhaps that's the biggest asset and they all need a home to live in. So they may have agreed adjustments which need to be fulfilled, but these cannot be activated, if you like, or initiated as an instruction to fulfill until death actually occurs. So we need to look through and see if there has been any of those discussions. Then moving on to what the others in their jurisdictions have referred to as intestacy rules, but here it would be implemented if you're in one of the jurisdictions where Sharia law is a fixed part of the legal system, then these succession rules would be automatically applied. And also they would be applied if you haven't done anything with the 1/3 opportunity that you had to write a will. If we're looking at that, then the most easy way to explain it is to go through a flow chart of who will be the primary inheritor, so that's the first category, who will be the secondary category and what their likely share is to be. And it's important to bear in mind that these rules will only apply if you are declaring the Muslim faith as a first stage. Most of the jurisdictions accommodate civil rules or secular rules for those who are non-Muslims and don't want these succession rules to apply. If going ahead with applying these rules, the primary eligible inheritors are the mother and father of the deceased, if they're with us, wife, husband, legally married spouse, and also the daughters and sons. So they will always be the first to have a share. And the best way of explaining what these divisions are, because one of the things I did a few months ago on LinkedIn was to share a post on what this flowchart looks like. So there's a really intricate way of pinpointing if you are a mother, father, wife, husband, what category you fall into, and then what share you have depending on how many other people happen to be alive at the time of passing, and that dictates the share that you may end up with. So one of the ways to share it here without going into an in-depth webinar on Islamic wills is an example. So if there was a husband who passed away, leaving behind a wife, a son, a daughter, and a mother, the wife's share would be 1/8 of the estate, which equates to 12.5%. If there was a son, one son, they would have 13/36, which is 36.11%. The daughter would be entitled or eligible, if you like, for 18.6%, which is 13th of 72 in a fraction format. And the mother and father, they're with us, they each equally inherit 16.67%, which is 1/6 of the estate each. In a scenario where there was a wife passing away, leaving behind a husband, 2 sons, and a mum and dad, the husband would be entitled to 25%, so that's a quarter of the estate. The sons would each inherit 20.83%, so that's 5/24 if we're putting it in a fraction. And again, mother and father equally inheriting 16.67%, which is 1/6 of the estate. So each example greatly varies depending on who is left behind at the time of death. So you can imagine it's quite hard to predict or impossible what that will look like, but each family can prepare for the different scenarios. If that set of primary inheritors are not available at all, then we move on to the secondary inheritors. They are eligible as additional family members, which are siblings and grandchildren can come into the mix. Then we have a third category that are searched for, which are more distant relatives. And then as an absolute last resort, similar to how we saw in the English law intestacy flowchart, where it would be the crown, in the Muslim majority countries, that there is a Treasury Department for unclaimed assets to distribute to good causes. And in Muslim minority countries, the wills can be drafted with a registered charity that is fulfilling the Islamic distribution. So that will be the final concluding destination, if you like, for the intestacy aspect. And that brings me to the conclusion, hopefully quickly enough so that everybody that wants to leave can, and ask questions too.
Yasmin, that was really fantastic and so interesting. I'm just
Thank you.
sharing my screen. I hope everyone can see. Feel free now if you want to come on your cameras. I've got some really incredible questions, actually. I know we are on time has gone past, but I think I speak for us all, it's been such an interesting webinar to just listen to the different jurisdictions impact. My mind's been blown. I would love to start speakers by questions. We had one submitted before today, and then I'm going to pop to the chat. Now, I'm not expecting everyone to stay on here, but thank you to those who are still here. And we will just ask a couple of questions, and then we'll stop, and you can continue the conversation on LinkedIn, or please contact on other committee members, and we'll speak to the speakers, or contact the speakers yourself. So, panelists, please may I ask someone to answer this fantastic question. So it's surrounding EU election and whether it's anticipated that this will continue to be a good way to ensure an English will applies to all European assets. A follow-up question to that as well is, if there's a blended family, and we would recommend life interest trusts in English wills, but trusts treated suspiciously in European countries, is it still best to refer to a cross-border specialist to deal with the wills? So that was submitted by lovely Jane Castle. I'm pretty sure she is on the call, so thank you, Jane. Would anybody, any of the panelists, like to come in to respond to that, please?
Yeah, I'd be happy to. give some thoughts from a French perspective. Yeah, as far as the choice of law question is concerned, yes, it is still recommended, because when you have a cross-border estate, it is always better to have some certainty, in my opinion, as to which law should apply. Otherwise, if you don't, you have to start asking yourself, where is the habitual residence? Where are the assets located? You can have conflicts of law sometimes, because the UK is not a party to the regulation. So it can very quickly become an absolute nightmare to, untangle. So yes, if a choice of law is possible, it is usually best practice to go ahead with that. Choice of law doesn't affect the validity of the will in other jurisdiction, but what it does change what law applies. In terms of the trusts, as far as France is concerned, we don't like them. I mean, I love them now that I practice in England, but the French are still very mistrustful, and especially there are a lot of issues surrounding taxation and reporting obligations, which people are always quite surprised to hear about, because we don't like trust, but we like to keep track of where there is an interest with France, because then we get to levy taxes, and that makes us happy. So yeah, that's the way the French view trust. Yes, absolutely still involved a cross-border specialist. You would not believe the amount of very niche things that will cause untold issues to a family. Like, you would want to do a life insurance trust, you could create a 60% inheritance tax liability in France with a life insurance trust, with a discretionary trust. We have issues with even just a deed of variation, which in France can be seen as a gift, again, giving rise to taxation. So whilst the choice of law can seem very simple, you're a British national, we just put the choice of you're a British national most closely related to either England and Wales or Scotland, to keep the jurisdiction separate. And so it can seem quite simple. We just put the choice of law in there, the will apply, we don't have to worry about it. But actually there are a lot of potential pitfalls, and don't expose yourself to, any professional negligence issues. Talk to a specialist. Obviously, we are extremely friendly and knowledgeable, and we're always more than happy to help to make sure that the client's wishes are protected and we're not falling into any kind of horrible taxation issues that nobody wants to deal with.
Thank you, Leah. That was fantastic. Jane, I hope.
Yeah, Paige, I would agree. Sorry to interrupt, because this also affects Spain. Just very quickly, I would agree very much with Leah. It's nearly the same. We really recommend the choice of law. What we also recommend is to do the formality of the will in the correct and right way from the very beginning. If you do a correct will, you shouldn't have any issues at all, and you are liable for anything that's wrong. But if you do it right, the choice of law is absolutely valid and it's recommended. As Leah was saying, it avoids misunderstandings, looking for the conflict of interest note, the conflict norm. Where is the last residence? It avoids any misunderstandings, and it's clear. It's very clear when the British law is chosen. I think Leah, you will agree with me, is the simplest way forward with a will. So that's definitely number one. And number two, the question was, sorry, I just forgot that. What was she asking?
Trusts
The
and life interest trust.
The same, the trust, famous trust, Lee. So we don't recognize trust in Spain. There is no legal figure like that. And as Lee was saying, big issue with inheritance taxes. A big complexity when we start to see a trust that has to inherit a property in Spain. That can be a big complexity. So try to avoid that, please.
Rosa, if we can continue with you, I've got a question. If a British national dies in England with property in Spain without a will in either country, this person's understanding is that the Spanish asset passes to the child under forced heirship. but would the administrator in England administer the Spanish property as well and can therefore apply to the court in England for the deed of inheritance?
No. Spanish inheritance works in Spain, and you need to go to execute the inheritance in Spain. We always work in coordination with English solicitors. We and my colleagues all work when there is a cross-border state in coordination, but we have to, the work has to be done in Spain. Why? Because, I mean, first of all, Spanish law only applies, we use the precedent, the precedent cases, if the testator, if there is only assets in Spain. If there are assets in the UK and in Spain, English law applies because that's the last habitual residence. It's not Spain. I mean, this has to be very clear. Spanish law only applies if everything that the deceased owned was located in Spain. But if there are assets in England, this does. We don't apply that. I mean, we apply the European regulation, which says that the last habitual resident law will apply to the inheritance. And in this case, if the deceased dies in England and lives in England and has links in England, strongest links in England, English law would apply. So how do we bring English law in Spain? With an affidavit. An English solicitor will sign an affidavit saying, in England, the law applicable to the inheritances is that, that, and that. So we know who is the beneficiary, but we execute that in Spain before the notary in Spain. And the notary in Spain will certify who is the beneficiary, and we will bring that deed of inheritance signed in Spain to the land registry in Spain to transfer the ownership of the assets in Spain to the beneficiary that's been named in the affidavit done by the English solicitor.
That's brilliant. And just a final one for you. Are there differences between in the regions of Spain on succession law? Or is it?
Yes. Catalonia is the very clear example, maybe the community that differs more from the rest. You all know Barcelona, Catalonia. The spouse, the surviving spouse in Catalonia is very, very, very well respected, much respected from the others in terms of rights as widower. And they get, even if they've got children, they get the chance to own 1/4 of the inheritance. As in the rest of Spain, you only own the rights to enjoy the life tenancy. In Catalonia, they can exchange the whole life usufructo, we call it life tenancy. They can exchange the right to enjoy of the whole inheritance for 1/4 ownership right to own 1/4 of the inheritance with the children. And when there are parents, the parents don't inherit. It's the spouse, the surviving spouse in Catalonia who will inherit with the parents. The parent only inherit 25% and the spouse inherits the rest. That's an example, the best I can give, I think, in terms of differences within the communities.
Thank you so much. Yasmin, please may I ask you a couple of questions now? One of them is actually a question that I wanted to ask too, but we'll start with this first one. How does an individual request Sharia intestacy over civil rules of the country of residence?
Yep, so this is the issue I guess Muslim clients face when writing the will. They will have to make a choice at the time of writing the will as to whether to go with the English law testamentary freedom, not intestacy rules of England, but a different choice, so English law applying, or at that time they write out the Sharia distribution because they want to fulfill those aspects. Without a will, if they are in England and Wales, they'll be subject to the intestacy rules of whichever jurisdiction they pass or are domiciled or resident in. So that's why writing the will for the whole of the estate is most important.
And one of the questions I wanted to know, and someone else has added that, what happens if there is a Muslim and non-Muslim? How does that work? So if you've got husband and wife, one is Muslim, one's not. How does that work in terms of can the Muslim still have that, would they need to have a UK will and a Islamic will? How does that work?
Yeah, so we come across that a lot more frequently nowadays, where you've got like blended families, now you've got blended faith. So blended faith families, they would have to sit down and make a decision as to what they want the distribution to look like. For the Muslim client, if they're looking to implement the faith-based wishes, they would have to remember that they're restricted to that 1/3, which gives them the freedom to go with someone who's a non-Muslim, who is not a family member, and that the non-Muslim spouse, if you like, should be advised that that would be the consequence if they write something that assumes or implies a full Sharia distribution is desired. But then also, if we're talking about England and Wales, that person who's a non-Muslim is a legally married spouse, meets the definition of a spouse. So they will have a 1975 Act claim to get what they felt that they should have. So very important to sit down together and go through that, because the non-Muslim client, of course, can still want to fulfill the partner's wishes of faith and kind of work something together that keeps everyone happy and out of dispute. That's the aim.
That's fantastic.
Yeah.
Interesting topic, having the faith side of it. I think that's really appealed to a lot of us. I've been so interested, I could talk to you about it all day. Thank you. I've got another question here. It says, what is the view of distribution of an estate where the deceased is a Muslim with 2 wives in the UK?
Yes, so this is a case actually that did end up in court, and one that I'm doing a much longer 2-hour webinar on about what happens. So briefly, to answer the question, is in UK law, there's legislation that prevents having 2 wives or 2 husbands or whatever, it's only 1 and 1. It would be bigamy. It's against the law. You cannot have 2 legal spouses. So you've either got 1 legal spouse who will then be regarded as the spouse for inheritance purposes, or what you've got is potentially 2 cohabiting partners, in which case neither of them are eligible as spouses. Or what happened in the case, which we're going to talk about in the webinar coming up in a few weeks' time, is the legally married spouse living in the UK. Muslim husband has gone to a country where multiple marriages are permissible under the principles of Islamic wealth distribution. So then they've got a legally valid, recognizable marriage, which is recognized in UK courts too. And so that estate ended up not how the testator intended at all, and HMRC got a big chunk too because of that not planning ahead.
So I think the importance is always to plan, get the right advice, make sure
Yes.
the right jurisdiction, but always seek specialist advice. Now, because of time, we've gone way over, but panelists, thank you from the bottom of my heart for giving up your time and expertise today. I think this will be something that we'll definitely go into more detail at another point. But I applaud you all for being fantastic women in the industry and shining the flag for us. So thank you on behalf of everyone who's here. Thank you for all of the questions that were asked. Please do connect with the panelists on LinkedIn. Please know Women in Wills hosts a private group on LinkedIn as well. You are welcome to come to that. We also run in-person events, and you can join our mailing list too. So I wish you all a really wonderful evening. Thank you for your participation. And again, thank you, panelists. You are just, well, you all inspire me a lot. So many thanks, and we'll catch up soon and speak soon.
Thank you, Paige. Thank you, everyone.
Yeah.
Have a good evening.
Thank you.
Bye-bye.
Thank you, everyone.
Bye-bye.
Bye. Thank you
Bye.
very
Thank
much.
you.
Thanks.